Welcome, everyone. It is with great sadness that I must announce this is the final Florida Bar Essentials course, and it's just been so amazing to be here with each and every one of you. And 90% of life is showing up and being active, being attentive, taking notes, and just being in the moment, right? I can't give that advice enough. Everyone in life right now is doing 7 things at once. They're texting this person, calling this person, plugged into everything. If you could just plug into bar study and plug into this moment right now, you can really learn a lot. Sam is going to do what she always does, get the vibes up, and then I'm going to come in swinging and talk about a lot of subjects today. It's going to be a diverse class, but I want to end the Essentials course feeling like everyone got a little bit of everything and that they feel all nice and buttered up to come to our complete course, which starts on Monday. So without further ado, Sam, the floor is yours, and we can't wait for what you have.
Hey guys, happy Monday. I hope everybody had a great holiday. I'm so happy to see everyone. I'm so sad. This is our last class, but I hope that through this administration that I do get to talk to and interact with you guys as much as possible. Like, I really love doing it. So don't forget to reach out if you need anything, because I am here for you guys. Okay. So can you guys see the screen?
Yes.
My PowerPoint?
Yes.
Perfect. Okay, guys, so welcome to November mini essentials course. This is week 4. Of course, is our Florida section. I just wanted to check in to see how everybody was doing. How was your break? I know this course was a very good example of what you will be doing when you're actually studying, as far as balancing your life and your assignments in class, of course. So I hope this was a good trial run for you guys. If it was not perfect, it's okay. We're about to get into December. That's the best thing about this course, is that we started early. So once you start early, you can make little mistakes here and there. So I hope you guys was able to get a schedule that works for you, and a formula that gets your teaching and learning skills together. And listen, we're in for a ride. Just know that the bar exam is not forever. That's the best thing to understand about this process. It sucks, but it's only for a few months and you'll be through with it at the end. Okay, so, I wanted to give some test day tips. Oh, sorry, go back. Test day tips for Florida. So, for Florida, it's a 3-hour exam. If you do get extra time, then that's amazing. But if you don't, then you only have 3 hours. My best advice is to do 1 hour per essay. Do your best subject first. So once you get there, you're in your seat, they're going to say, you can begin. They're going to give you your packet and you're going to read through every essay to at least notice what subjects they are. Once you see your best subject, the subject that you know most of the rules, you're going to start there. It's going to get your juices flowing. Most importantly, it's going to get your confidence up. So always start with your best essay. Try to do 1 hour per essay. Even if this is your best subject and you can add a little bit more, give it an hour. Go back to your other subjects, your other essays, and then come back to your favorite subject if you have time to add a little more razzle dazzle. Like I said, #watch the time. I am a very big time clocker. I like to know when when I'm halfway through. I like to know when I'm 30 minutes to the end, because once you have only 30 minutes left, that's a lot of time to get your mind right and get your essays together, because once the time is over, you can't do anything after they end it. The best thing I want you guys to do is organize your essays. If you do run out of time, make sure you're putting in headers, highlighting what issues you're talking about. And a lot of times on the essays, they have multiple causes of actions and multiple parties. So if you're talking about A versus B, make sure you headline it there, A versus B. If you're talking about an ethics issue, you can go ahead and put ethics issues. So organize your essays so it's easy for them to read, because again, they're going to be reading hundreds of essays, and you want to make your essay the easiest one to grade, so you can just move on and get all your points. Okay, I know a lot of people like to outline. Sometimes it's not the perfect thing for everyone, especially if you get a little nervous, and sometimes time is an issue for you. But for sure, you need to start identifying all the issues you see when you start reading your essays. Even if you might be incorrect at the end, you just never know. Anything that piques your interest and you can add and attach it to a rule or issue is perfect to just write it down on your margins. Or I would do it like on the back of the scratch paper, and I would just literally list all the issues I'm going to write. So when I get to the end of my essay, if I have a little time left, I'll go and make sure that I hit every issue, because sometimes you can read it one time and then pick up an issue and then get so lost writing your other issues that you'll forget that you identified that issue. So if you start in the beginning with putting all your issues down, then you won't forget it and you'll cover all your bases. I hope I don't offend anybody when I say this, but please don't leave the exam early. Please don't leave the exam early. You have 3 hours. Like, don't leave the exam early. Literally, if you know you have 30 minutes left, use the 30 minutes to your advantage. Check your grammatical errors. Put your headings there. Like, you have time, use it. Do not leave this exam early. Please get all the points that you can, okay? And my last tip is to please breathe through it. I think the essays are usually the most intense because you don't know what they're going to test, right? And we're all guessing. We're all saying, oh, it's going to be this, we're going to be that. You're going to hear chatter through the hotels. You're going to hear chatters in the line. Everybody's going to try to guess what it is, but it doesn't matter what it is, because you're going to get prepared and you're going to know, and you're going to be able to write an essay on any essay subject on game day. That's how you're supposed to go to the exam. You don't go to the exam hoping and wishing that they have only this subject or only that subject, because you never know what you're going to get. Especially when it comes to Florida, they love throwing their little secret sauces in there and their little secret ish. I'm telling you, it's never going to be exactly what you think. So just focus on learning the rules and breathe through it. If you feel like you have a blank, just keep going. Just keep going. You are a lawyer. Think like a lawyer. Think of your causes of actions. Think of what you think somebody could be guilty of, what defenses they have to it. Just think of realistic things, because that's all it is. They're giving you a fact pattern. They're giving you all these details. And just like a real life lawyer, someone's going to come to you and say, this is what happened, and this is what happened, and this is what happened. And you got to tell them all the remedies that they can seek and everything that they can do. So this is just a pre-attorney exam, okay? You're an attorney. You got this. Breathe through it and don't give up to the end. Do not leave early. Okay, thank you. Okay, so the biggest thing about Florida is memorization. So I want to give you guys a few tips for memorization. For one, you need something to memorize from. You have to create it. That is just, it is gonna suck, but you have to create it. You can't memorize somebody else's words, okay? I promise you. Even if you take it from a different document, you're still always, when you write it, you're going to see yourself, you're going to rewrite it in your own words. That's just how your brain is going to function. So write your outlines, get you a notebook, get you flashcards, whatever works for you, but you need to have something that you're going to memorize from, okay? And my favorite memorization method is the teacher method. I made that name up. I don't know if it's real. That's what we're going to call it from now on. But you are the teacher, okay? You are teaching contracts 101, all right? You are teaching it, and if there's a cat in front of you, a dog in front of you, nobody in front of you, doesn't matter. You're going to teach this course to these people. You're going to teach them what you need to write on a contracts essay, a torts essay. You're going to be the professor. When you can speak rules out loud and explain them, and it's like you're going to get into your knowledge should be at a point where you can explain it, and sometimes you won't even explain it at the same time every time you teach yourself or teach the air or your cat or your dog, but that's how you know when you know something, when you can recite it in multiple different ways and just recite it from the top of your head. That's the type of knowledge you need. I remember the day of the Florida bar exam, I was so nervous, and I just was like, oh my God. And then my higher self said, Sam, you know this stuff. All you need to do is go ahead, show yourself that you know this stuff. Start reciting torts. And I literally recited torts from A to Z, waiting for my hotel room to be ready. And that's when I realized to myself that I'm okay. I covered my bases. I memorized what I need to memorize, and I'm going to put it on that paper. Okay. I like to organize my rules in subsections. Okay. So when I used to teach my fake class, I used to always say, hi guys, I'm going to teach you torts. In torts, there are multiple kind of torts. There are intentional torts, there's negligence, we have product liability, you know what I'm saying? So that way I'm marking all my subsections, right, that I need to know that come with torts. And then I go deeper. For intentional torts, the intentional torts are assault, battery, intentional infliction of emotional distress, trespass to chattel, trespass to land. And then from there, I'll go and memorize what is a battery, what is an assault, etc., etc. So if you organize it in a way where you're memorizing and you're basically adding everything together, but piece by piece, so you're not overwhelming your brain and saying, okay, I need to memorize all this at once. No, start with one section, negligence. The duties, negligence is when duty, breach, causation, damages. But for duties, there's a lot of little rules under duties. Duties to who? Every different relationship has different duties, etc. So put everything in little groups and then memorize them like that. So that way, when they flow together, the rules will be easier for you to memorize because you're kind of, mixing them together and you won't forget the rules that go together. Because if you're talking about intentional torts, 9 times out of 10, you got to make sure you're talking about battery and assault. Even if you don't see an assault on that exam, you're not going to forget assault. That's an easy one to throw in there. Product liability, they're going to have little issues, but you can pick so many rules that can attach that issue. And if you keep them all the rules under each issue, it'll be so much easier to memorize. Another tip I would say is I love to handwrite. I think handwriting will expand your memory to the T. It's muscle memory. And on top of that, even though you're not writing physically, you're typing, is still about making your brain put something on paper, making your brain formulate the sentences in certain ways. You'll see with practice that your brain is just going to automatically put things together and is going to remember things that attach to it. You're going to remember assault is reasonable apprehension of a harmful or offensive behavior. And then you're going to remember that, assault can't just be words, and assault has to be in the moment. Like I have to be scared in the moment. I can't be scared tomorrow. So when you write your rules and you make sure you're putting all your rules together, you're going to memorize them together. You're going to memorize every little sub rule that you put for every rule because you wrote it down and you put it together, and your brain is going to organize it that way, especially through practice. Another thing you can use for memorization, of course, is flashcards. A lot of people love flashcards in law school. I was a flashcard girly. But for the bar, I had to switch it up a little bit because I think the flashcards are very timely and they can take a lot of time. And then you're going to be picking and choosing, oh my God, what do I put on this flashcard? And then you're going to be losing your mind about what's on this flashcard. Then you're going to miss something on the flashcard. Then you're going to try to add it. I gave up on the flashcards, but if it's your thing, please do it. Because of course, this is something that works for you, right? Recordings. I have not done this tip, but I wanted to share it because I have heard that it has been effective for certain people. But some people, they record lectures, they record their outline with their voice and they listen to it when they're in the car, when they're in the gym. It can, help you retain the information, and like when you hear something in your own voice, it just resonates a little different. But again, that might be another timely assignment, but of course, do what works for you. But these are some things I think work when it comes to memorization. For the Florida bar, you have to know there are certain rules you cannot miss. Okay, that's all it is about Florida, is knowing your rules. So I have a few slides of some rules that good to say they're going to be on the exam, or something that you should prepare to see if this subject comes on the exam. Okay, don't go to the bar not knowing what an intentional tort is or not knowing what negligence is. Okay, essays, you're going to see negligence. It's guaranteed. I'm sure if you see a tort essay, you're going to see negligence. Of course, with contracts, contract formation, contract defenses can be really big for your points. I'm going to upload this on our classroom, so don't worry. What are requirements for bill formation? These are easy things to memorize. They're like 5 things. What is the Sunshine Law in Florida? What is the Equal Protection Clause? You got to know what the Equal Protection Clause is, okay? What is a mortgage? There are just rules that you just have to know. What is the legal effect of adoption? The last bar exam, they killed adoption, right? Be familiar with things. What are the requirements for valid trust? Of course, guys, you just have to know your rules. I just wanted to close and say it's been an honor to be here with you guys. I really, really want you guys to reach out. Let me know if you need anything, even if it's a 10-minute conversation. I will gladly take the time to give you guys some encouragement, put you on the map, get you back to where you're going. Remember, this study process is only a few months. Your freedom is a day closer every day. Okay, take that into consideration. Do what you can. Make sure you're actively studying. Don't just be reading outlines. Don't just watch videos that you're not paying attention to. Write something down, formulate an outline, do practice questions, issue spot an essay. Even on those rough days where you can't study or you feel like my brain hurts, give yourself some days off. But remember, you have to put in the work. Try to push yourself as hard as you can. Don't kill yourself, of course, but push yourself. Remember in those days in law school when we were trying to get through 1L year, we're like, damn, how we gonna make it? And look at us now. We used to be 10, 20 steps away from being attorneys. And now the only thing in your way is one exam. You can do this, okay? Below it is, I always give you guys a meditation for the week. So that's my meditation for the week. It's a meditation for students studying, which is, of course, appropriate. And again, I am Samantha Collier, your fairy bar. Contact me. Please contact me. Please contact me because I'm here for you. And we're going to kill this bar exam. We started early. We're on the great foot. I hope I see you guys back in December. And it's been a pleasure. Thank you so much for your time.
Thank you so much, Sam. Amazing. On Zoom, you can't hear the wild round of applause that you would get in an auditorium, but just know that people are clapping for you. So yeah, fairy bar mother, amazing. And now me, complete opposite, right? I'm just gonna teach you all the law because I think it's important to know the real essentials of this test. But Sam is here for everyone. Reach out to her, especially by midnight if you want to partake in our Cyber Monday sales. And yeah, really, really great stuff, Sam. I couldn't agree more with what you're saying about when you're in the gym, when you're in the car. I mean, I would listen to videos and I made my own videos. And like you said, record yourself, listen to yourself. I see people who have whiteboards that they filled out, notebooks that they filled out. Like, really go above and beyond and obsess over this and treat it like it is the most important thing in your life. Because I'll tell you something, there's people all over the world that would do absolutely anything to be in your shoes, which is one measly test away from practicing law. I can't say that with enough sincerity. There are people who would trade anything to be in your shoes right now. And if given the opportunity, they would study so hard and they would make sure that failing was not an option. Now, is failing a possibility? Absolutely. There's a reason why there's so many retakers. It's an extremely hard test. So, we're going to do what we can day by day to push ourselves in the favor of passing and away from the possibility of failing, but never too high, never too low. Just focus on the material. So, and the meditation and the mindfulness and loving yourself and all that is very good stuff too. But I'm going to really focus right now on some of the material from this test. I've noticed that no one completed all the homework yet, but there's still time. So, continue working. I still have some essays to grade, and I'll continue doing that this week so that all the essays are graded. And I can't stress enough, every subject there is 50 questions on our multiple choice Q bank for the Florida multiple choice section. And if you can just go through those questions over and over and memorize them all, you'll be doing yourself a great favor because we're going to add some new questions maybe in January or February. But for now, those are sufficient. If you can master them, you'll do fine. Okay. I'm going to start off by talking about family law because family law is the one essay subject that we haven't really discussed in depth yet. So everyone can see my screen. I'm going to go over these subjects very quickly. So, just take notes, learn, and just know that there's time. But if you can learn some key things today, it'll be a great night. So the first thing is family law. Has anyone ever heard of the mnemonic we created, JV Peast? MJV Peast. I want everyone to write that down on their paper. MJV, PEACED, right? The M is going to stand for modification. The J is going to stand for jurisdiction. The V is going to stand for venue. So modification, jurisdiction, venue. The P is going to stand for parenting plan. The E is going to stand for equitable distribution. The A is going to stand for alimony. The C is going to stand for child support. The E, we say esquire fees or everything else. And then the D, the most important one, is divorce, right? And remember, does anyone know what type of divorce state Florida is?
No fault.
Florida's a no-fault state. And in Florida, what is necessary to petition for divorce?
The marriage must be irretrievably broken, or one of the spouses suffered incapacity for the past 3 years.
Excellent. Did everyone get that? You can file
Yeah.
for divorce in Florida if the marriage is irretrievably broken or one party has been rendered incompetent for over 3 years. Excellent. So MJVPs, we're talking about modification. And does anyone know when you can modify a final settlement, a final divorce settlement in Florida?
You said, when can you settle it?
When can you modify it? What do you need to show in order to have a
Whenever there's a significant change to your financial status or a change in something that happens to the object, like if it's child support and something happens to a child, they have more needs or less needs, you can ask for modifications then. Usually they say
Excellent.
between 5 and 10%.
What I would call that is an unanticipated change in circumstances or events. So we can have a modification, not if it's something that we anticipated when the final settlement was created, but if something changes that's unanticipated or significant, then that could give rise to a modification. Okay, so we have the M is when there's a modification. What about the J? The J stands for jurisdiction. So that's something that I noticed in some of your family law essays that I started to read. A lot of you all skipped over the jurisdictional aspect of a family law question. Remember, anytime that there's a family law essay, there's going to be a necessary discussion of which court in Florida has jurisdiction over the case, right? So that's what the J stands for, jurisdiction. And when you're looking at jurisdiction, it's really the same as it would be in any civil procedure analysis. You're going to do personal jurisdiction, subject matter jurisdiction, and venue, right? So here we can see it finally written out. MJVP, modification, jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, everything else, and D, dissolution or divorce. We talked about the modification being a unforeseen change in circumstances, right? So unanticipated change in circumstances, we would allow for a modification. And then we get to the jurisdiction slide, which, as I was discussing, is personal jurisdiction, subject matter jurisdiction, and where are we going to have PJ? Same as in normal civil procedure, where there's consent, service, domicile, minimum contacts. Subject matter jurisdiction is where, you know, one of the spouses or parents has been a resident for at least 6 months before the dissolution. And then it's the same for the child, where the child has been a resident for at least 6 months. And whichever court issues the final settlement, will have continuing jurisdiction over, let's say, a modification or a petition to move the child or something of that nature. If you can remember one thing when it comes to family law, remember the best interest of the child. When in doubt, this is what we'll do for the best interest of the child. A Florida essay, family law, it's pretty much guaranteed that a Florida court is going to have jurisdiction. It would be very rare for your analysis to lead to the conclusion that the Texas court will have jurisdiction and therefore I'm not going to apply Florida law in this essay, right? So just do a general jurisdictional analysis that allows you to determine that Florida has jurisdiction over the case because the parties have lived there for the last 6 months. They've established minimum contacts. And furthermore, they have venue. Remember, venue being location, and that analysis will be based on where the cause of action occurred. So, what gave rise to the divorce, or, where either of them live or the court would have personal jurisdiction over the party, right? So remember, modification, jurisdiction, venue. Then we're going to go into the parenting plan. And when we're talking about these subjects, you don't necessarily have to do them all in order. It's not like contract law where you do MJV pieced in order. I'm just saying that's a good mnemonic to remember the things that you could talk about in family law to get points. Parenting plan is easy, best interest of the child. I had a family law attorney who said, don't use the word custody, use the word time sharing. I see them use the word custody on model answers, so I'm not as strictly opposed to the word custody, but just know that that means time sharing over the children. You'll get a point for mentioning that in Florida, you have a constitutional right to raising your child, right? So mention that. If they're going to strip you of the right to raise your child in a divorce settlement, you really must have messed up. It would be a strict scrutiny analysis, right? That would be called sole authority. We have shared, ultimate, and sole. Shared means Andrew and Melinda are going to, split everything. Ultimate would be Andrew has, authority over educational decisions, and Melinda has authority over sports and fashion. And then sole, again, we said only if Melinda was hooked on not phonics, the other stuff, then I would probably get sole authority. But again, it's very difficult to get sole authority in Florida because we want the kid to be raised by both parents. That at least is the presumption. Now, equitable distribution, a big one. You're not writing a Florida bar essay on family law without writing about equitable distribution. This is what we do in Florida. If you want to learn about other states, you could, but Florida, we do equitable distribution. We are a marital property state. Simply put, that means there's marital property and non-marital property. Marital property is property that was acquired during the marriage. Non-marital property is property that was acquired before or after the marriage, such as an inheritance or, just money that you had before you got married. Now, let's talk about some difficult concepts. A pension, right? Tommy and Brittany are married. Tommy, let's make it non-traditional. Brittany's working the job and Tommy's cooking at home, right? Now, Brittany gets a pension for working at her job, but they get divorced after 15 years. You don't get the pension until 30 years, right? Well, Tommy is entitled to half of that pension because for 15 years, he was part of the marital, team that was making food for the kids and earning a pension. Think about it like that. We're a unit. Think about it if you get married. Okay, so pop quiz, hot shots. No, we're not doing that today. Sorry. ¿Qué más? Alimony. Alimony is very important. They've actually eliminated permanent alimony, and Danelise is editing as we speak tonight our outlines to make sure they're updated 2023 with the new forms of alimony. They've also changed the presumptions of marriage, short-term, moderate, and long-term. Now it's 10 to 20 above and below where it used to be. Who cares? But right, just know you must know the newest law, and we do have it on our outline, and Danelise is combing through everything right now in the classroom. All of our editing materials in the Google Classroom. So temporary. When you write a discussion and you're going through alimony, you just want to go through the pieces: temporary, rehabilitative, bridge the gap, durational. I would include pendente light. We'll say it either way, so you can hit on me for both mispronunciations. Pendente light, I guess. That is alimony for the pendency of litigation. Prenups and postnups, you should certainly talk about, right? They need to be in writing. Prenups, because it's statute of frauds. Postnups, statutorily should be in writing. Let's see, peace. We got to talk about C. Now, child support can be very difficult if you're a family law attorney. You're not, you're just writing an essay. But there is a way that they do child support. They basically take the income of the mommy and the daddy, or the daddy and the daddy, the mommy and the mommy, whatever they are. They take their incomes and then they add them together, and then they put it on a chart, and then you can deviate up and down 5% from what you're supposed to pay by statute. You could really condense that into a nice little sentence that just says this: the court totals both parents' net income and finds the support amount in the statutory chart. The amount is then allocated between the parents accordingly and their respective need and ability to pay. The good thing about family law is if you grew up on planet Earth, you're probably familiar with one of these legal battles, and you could just harken back to what happened when Aunt Martha got divorced and Bobby tried to take all the money and they screwed over little Jimmy, right? Like, think it through. They should have done what's in the best interest of the child. It should have been in a Florida court because they both lived there for the past 6 months. We're going to talk about marital property. So thankfully, you know, Martha got to keep that at grandma's house. You know, just think about it like that. Talk about the factors. What's the best interest of the child? The child's education, the child's, you know, familiarity, friends, you know, all that good stuff. But just write your heart out. Everything else, I really think of attorney's fees. Will Watson, my man, said cite Rosen v. Rosen. I feel like that's like Alex Earl. Alex Earl said wear cranberry nails, so I wear cranberry nails. Will Watson said Rosen v. Rosen, so cite Rosen v. Rosen. I've never cited that in my life, but you can't lose points. So that is a way of saying that attorney's fees can be granted in domestic cases based on ability to pay need. We know that, of course, that contingencies are not available in domestic cases. And then the D, this could come first, right? The first thing you could talk about is Florida is a no-fault divorce state. The marriage needs to be irretrievably broken, or one party needs to be rendered incapacitated for at least 3 years. I know Florida's a no-fault divorce state, irretrievably broken, mental competence for 3 years or more. I feel like that was pretty sufficient in a quick draw family law presentation. Does anyone have any questions for me about family law at all? All right, let's move right along. I'll do secure transactions. And again, some of these subjects I might not even pull up the PowerPoint. I'm just going to kind of breeze through them. I'll tell everyone about secure transactions and commercial paper without even doing PowerPoints. Can everyone see me? Okay, good. That's all you get is me. And here, this chess piece, right? Some visual antics. Okay, so commercial paper and secure transactions, Article 3 and Article 9. Commercial paper, Article 3, secure transactions, Article 9. How can I explain those subjects so simply to y'all? By explaining the concept of a mortgage. Fair enough? Does anyone know what a mortgage is? A mortgage is a loan secured by property. A loan in which property serves as collateral. An IOU, let's say, let's dumb it all the way down. An IOU in which if you don't pay back the money, they take a year home, right? That's what a mortgage is. An IOU where if you don't pay back the money, they take a year home. Now, we got to split that up and realize it's actually two pieces of a mortgage. There is the security agreement, right? That's the collateralization agreement. That's the agreement that attaches, ooh, that's a good word, that attaches the property to the loan, right? If you don't pay back the loan, I take your house. That's the security agreement. And then there's also the promissory note, right? Which is the mortgage note, which is, hey, I'm going to lend you $100,000 to buy this tiny little blade of grass in Dade County, and you're going to pay me back this plus interest rates plus, you know, your mom's furniture and your liver and all that, you know, and that's how it works. There's a promissory note and there's a security agreement. Does that make sense to everyone that a mortgage is actually 2 instruments. A property mortgage is actually 2 instruments. Now, why is real property mortgages different than Article 3 and Article 9? Because the collateral is not real property. It is specifically not real property, right? It's everything else. Secured transactions, what is it? It's inventory. It's consumer goods. It's farm equipment. And it's accounts receivable, things like that, right? What am I missing? Inventory?
Trademarks, non-intangibles.
Yeah, intangibles. But what are the 4 tangibles? I'm sorry. Farm
The
products?
stock is the animals, how do you say that? Is it stock?
Farm equipment, consumer goods, equipment, and does anyone know?
Livestock?
No, not livestock. It's farm equipment, or equipment. Oh, inventory. Duh, inventory. Okay. Consumer goods, farm equipment, inventory, and right. And the difference between equipment and inventory is equipment is like the tractor used in the process. Inventory would be like if you had thousands of tractors in storage. And then farm products are like actual livestock or like corn or something like that. And then consumer goods, the difference between consumer goods and inventory is in the back, consumer goods are what are being sold. So let me reel that back. See, I froze on camera, but I haven't frozen myself. There are types of tangible collateral that are regulated by Article 9, right? Secured transactions is kind of like a mortgage where we're attaching a loan to a piece of property, but instead of it being real property like a mortgage, it's going to be either something tangible, like those 4 things I said, consumer goods, farm products, equipment, or inventory, or it could be attaching to something intangible, like accounts receivable, or someone said IP or trademark, or a promissory note, which combines a lot of things. But that's the concept of a secure transaction. We are going to have collateral. The collateral could be tangible or intangible. There's the 4 types of tangible: consumer goods, farm products, inventory, and equipment. And then there's tangible intangibles, like a literal check. And then there's intangible intangibles, like accounts receivable or IP patents, right? So what does it mean to attach? It means that the debtor and the creditor have rights in the collateral, right? The person gives rights, and then the person who lends the money, let's call them the lender, they receive rights, where if you don't pay back the loan, then they could, same situation, foreclose or take over the goods, right? So how do you attach? You attach by a security agreement. That's the main way that you attach. A security agreement gives rights in the collateral. Let's think about that. A security agreement gives rights in the collateral. You usually need a security agreement. Sometimes you don't. You could take you can attach by possession or control, right? But if it's a car, you are going to get rights in the collateral via attachment, and the attachment will occur with a security agreement that establishes the debtor and the creditor, that describes the collateral adequately. It can't be super generic. It has to adequately describe the collateral, and it is in writing and signed by the parties, right? Not necessarily signed by both parties, but signed by the party to be charged, let's say. So rights in the collateral via security agreement. That's how you establish rights in the car, let's say. Now let's say Tommy and Johnny both create security agreements in the car, and they both say, hey, I didn't get paid back, I want the car. Who has priority? And remember, this is basics, this is 101. You establish priority via financing statement. Basic, essentials, right? Attach via security agreement. Priority is established via financing statement. It's a lot like lien law in real property. If you think about it like that, like multiple people have liens, who has priority, first mortgage, second mortgage. It's the same concept. It's here, who filed the financing statement first. That means you perfected. Perfected will always prevail versus unperfected. And then first in time, first in right, if it's perfected versus perfected, or if it's unperfected versus unperfected. Now, there is one very important type of security interest in Article 9. If that's all you take, everyone's going to take one takeaway, right? Takeaway from family law, best interest of the child. Takeaway from secure transaction, the thing that they would test on a multiple choice question, everyone should write this down. PMSI, a purchase money security interest, very similar to a PMM in property. I wonder why, right? If you're listening to, if you're catching my drift here, it's the very similar concepts. Purchase money security interest is basically, not basically, I'm not supposed to use that word, is essentially the collateral is what they have rights in. So if there's, I lend Tommy money to buy a TV and I establish rights in the TV, the consumer good, the television, it's usually, let's say, Best Buy. Best Buy will finance the TV for you and you'll, pay them back. But if you don't pay them back, they can repossess the television, right? You can repossess as long as you don't breach the peace. If you need to breach the peace, then you need to seek a writ of replevin, to recover from the sheriff. But you're allowed to get your goods back as long as you're not breaching the peace. So a PMSI is going to have super priority. Let's coin that word today. Super priority, meaning it'll prevail even if it's second in time. Here's a smart sentence. You can go tell this to your neighbor and sound smart. Instead of singing a Christmas carol, knock on the door and say, knock, knock, knock. Did you know that a PMSI has second in time, first in right priority under Article 9? Right? And then slam the door and say, find your savior, right? So PMSI, purchase money security interest, is going to have super priority. If that's all you remember from Article 9 today, so be it. But that just means you paid some attention. Secure transactions is simply tested on the Florida bar exam. It's a multiple choice subject, so you don't need to write essays. You just need to think, oh, is this an attachment, be a security agreement? Is this perfection, be a financing statement? Is this priority, perfected versus unperfected? Perfected will win. First in time, first in right, if they're both perfected or both unperfected. Aha, is this a PMSI? Did they actually acquire rights in the things that they use the money to buy, much like a PMM? Then they'll have super priority. And as we're going to go carol around on the streets, that under Article 9, a PMSI has second in time, first in right interest. Okay, any questions about Article 9? I'm sure there's a lot, but any one question for me, maybe, about family law or Article 9? Or we want to keep rolling with Article 3?
No puedo creer, Dios mío, callar un poquito.
Okay. Grace, can you translate that for me?
Ya nada.
Okay.
She's speaking to someone else.
No, I know, I get it. I was just making jokes, I guess. Anywho, let's talk about Article 3. So Article 3 is commercial paper. Commercial paper is a negotiable instrument, right? Commercial paper, negotiable instrument. So think of a check, simply. Now, there's two types of negotiable instruments. There's notes and drafts. Notes are two-party instruments. Drafts are three-party instruments. A check is actually a draft. Grace wrote me a check for the holidays, and I cashed it at the bank. Three parties, right? Grace, the drawer, she drew it. Andrew, the drawee, or let's just call me the drawee, or the payee, that word, like the person who's, gets the cash out. And then the intermediary there was actually the bank, the drawee/payor. Let's back that up. In that situation, Grace is the drawer, she drew it. The bank is the drawee/payor. The drawee in terms of the Grace bank relationship, and the payor in terms of the bank Andrew relationship. And Andrew is the payee. That's the easiest way to phrase it. If it's just a note, there's just, let's call it a maker and a payee. That's easier. If it's a note, it's a maker and a payee. If it's a draft, there's a drawer, and then the intermediary, who's the drawee/payor, and then the person who gets to cash it, the payee, right? If that doesn't make any sense, try your best to listen hard this time. A note is a two-party instrument. There is a maker and a payee. The maker is the person who makes it. Maker and drawer pretty much mean the same thing, right? The person who makes it, and then the payee, the person who can cash it in. That's a note. A draft is a three-party instrument, and there's a drawer, person who draws it. There's the intermediary, and we're going to call them the drawee in terms of the relationship with the drawer, because they're cashing them out, or they're taking money from them. But then they're the payor in the sense that they're paying out me, and I'm the payee. So drawer, and then intermediary, which is drawee/payor, and then third party is going to be the payee. Simple, right? So what is this? This is an IOU. Now, in my old days, I see the grays in my beard, right? Everyone had to point that out over Thanksgiving, amongst other things. No. What am I talking about now? No, I'm just kidding. So commercial paper, in the past, I used to have my class sing this song because there was an essay and they needed to know this by heart. You still need to know it by heart to get the multiple choice questions, but we're not going to sing. I'm just going to tell you. What is a negotiable instrument? It's a medium of exchange for money, but it doesn't include cash or securities that can be transferred, right? That's a great definition. It's a medium of exchange for money that does not include cash or securities that can be transferred. It can be a draft or a note. Draft is three-party instrument, note is two-party instrument. Now here's the poem that I used to have everyone remember. Rosie, shut up. A negotiable instrument is negotiable, right? It satisfies the conditions of negotiability. If it's a signed, written, unconditional, promise to pay, a fixed sum of money, with or without interest, on demand or definitive time, to order a bearer with no additional undertakings. And if you see, I know it so well, I'm just trying to focus on my dog not barking. I'm not even trying to focus on the definition. I'll repeat that. Just give me 1 second. Sorry. A signed, written, unconditional. That's the big one. They love testing. It's conditional. I agree to pay Tommy Jones $150 if the Dolphins win the Super Bowl. It's conditional. It's not Article 3. It's just a contract. It's just, I don't know, offer acceptance consideration. It's not what we're dealing with here. Signed, written, unconditional, promise to pay a fixed sum of money with or without interest, on demand or definitive time, to order or bearer with no additional undertakings. Order or bearer, what does that mean? To order means it's to Andrew, and Andrew can only Andrew could sign it. You could turn a check into order paper. A check is technically bearer paper. Bearer paper means all you need is possession. Order paper means you need possession and endorsement. What is endorsement? A signature, right? Very simple subjects here. Technically, a check is bearer paper. I can cash it in check. If someone ever writes you a check and you lose it, you should call the bank and cancel it because someone could actually just cash that in. I know that sounds crazy, but if you bear a check, you can cash it in. The bank might not do it, but technically you can. Now, order paper, if you turn the check over and then write to Grace, and then she has to sign it to cash it in, that's order paper. Order paper is to someone and it requires endorsement. Bearer paper is transferred just by possession. So, signed, written, unconditional. That's a big one. They're going to give you this thing, there's going to be a condition. Signed, written, unconditional, promise to pay a fixed sum of money with or without interest, on demand or definitive time, to order or bearer with no additional undertakings. On demand or definitive time, it can't be like sometime in the fall, or it can't be like additional undertakings, like, but to cash this check, you need to go climb the mountain. It's got to just be, you can cash it. That's going to be commercial paper. Now, remember, we're learning one thing at a time here. Family law, best interest of the child. Secure transactions, we learned about PMSI. Commercial paper, I want you to learn about a holder in due course, right? A holder in due course is so similar to property law because of the concept of a bona fide purchaser, a BFP. In real property, a BFP is someone who takes for value in good faith without notice. In commercial paper, a holder in due course is someone who takes for value in good faith without notice. Both holders in due course and bona fide purchasers follow the shelter rule, which states that a subsequent holder downstream takes shelter in their status as a holder in due course, meaning even if they're gifted the property or they're gifted the instrument, they still take shelter in the HDC status or the bona fide purchaser status. It's very okay to think of bona fide purchasers and holders in due course similarly, because they are. I'm cool with that. Now, you know, the top professor at Harvard might be upset. Not me. I want you to understand these things at their basic, at their essential level, right? So, what's cool about being a holder in due course? Well, you take free of the personal defenses and you're only subject to the real defenses, right? Personal offenses are like the contract offenses, right? So those are like, invalid consideration, or, there wasn't a good agreement or something, whatever. Fraud in the inducement, let's say. Whereas the real defenses, the mnemonic phase, fraud in the factum, alteration, illegality, duress, discharge, suretyship, statute of limitations. Again, you don't even really need to know these things deeply. Just know what I'm teaching you is that being a holder in due course is nice because you are not subject to the personal defenses, the contract offenses. You're only subject to the real defenses. If you can't remember real offenses or personal offenses, remember the fraud one. Fraud in the factum is a real defense. Fraud in the inducement is a personal defense. So holders in due course are nice, and shelter rule applies to holders in due course, right? To a holder in due course. Then there's presentment warranties and transfer warranties. Presentment warranties mean, when you give someone an instrument, you're warranting that they have the right to present it, that there's no fraud or alteration on the instrument. Same thing with the transfer warranties. You're warranting that they have the right to transfer it. There's no fraud or alteration on the instrument. Just remember, good faith will always come into play. These questions are not going to be hard on the test. You hope you get commercial paper and secure transaction questions on the test, right? So we talked about commercial paper being a check, an instrument, a medium for exchange for money that does not include cash or securities, that can be negotiated via transfer or endorsement if it's to order, transfer if it's bearer paper. We know an order for one of these instruments to be negotiable. It needs to be a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order, bearer, no additional undertakings. And we know that commercial paper, there's notes and drafts. Notes are two-party instruments, drafts are three-party instruments. And I'm pretty confident in that. Secure transactions as well. I stumbled a little bit on something very important. There's 4 types of tangible types of collateral: consumer goods, farm products, inventory, and equipment. There's intangible tangibles like accounts receivable or IP patent, and there's tangible intangibles. Isn't it small world after all? Here's an example of a tangible intangible: commercial paper. Grace, I give her a loan, and to secure it, I have rights in a check. That check is a promissory note. It's commercial paper. It's a negotiable instrument, but it's serving as collateral in our secure transaction agreement. Now, I could probably attach via possession because it's a instrument or control or something, but let's say it was a car, then I would attach via security agreement. I would establish priority via financing statement, and if I had a PMSI, I'd have second in time, first in right priority. And then if I had this interest in this security instrument and I had it before I got married to Melissa, well, that would be non-marital property, right? If we got divorced later and she said, la la la, I want that, whatever, I got it before the marriage, non-marital property. See, think like me. Your life should just always be thinking of scenarios where you could think about how Florida law is going to apply. All right. So not so bad with the timing, actually. We've done secure transactions, we've done commercial paper, we've done family law. I mean this honestly, because I'm actually moving along nicely. Does anyone have any questions about those 3 subjects right now?
I went ahead and sent you one question on the chat.
On the chat? All right, bet. Let's
It's
see what it
short.
says. So the difference between a holder in due course and a non-holder in due course, the main one is that you take free of the personal defenses. So if Tommy has an instrument and he's not a holder in due course, Johnny has an instrument, he's a holder in due course, and then someone says, hey, you know, that instrument, he was induced into writing it, or hey, that instrument was, you know, there wasn't adequate consideration when it was created. Those things would potentially apply to someone who was not a holder in due course, but they could not apply to someone who's a holder in due course. Think of it very similarly to the bona fide purchaser protections, right? In Florida, does anyone know what type of notice statute we have?
You talk about the first.
Notice recording start.
Yeah, what type of, what do we call it? Pure notice, right? We're pure notice jurisdiction, meaning that bona fide purchasers are going to prevail. What does that mean, they're going to prevail? It means that they have priority over other people's claims on it. The defense is that, oh, you know, Tommy, whatever, unless you have notice, unless you have actual inquiry or constructive notice. But if you're a true bona fide purchaser, then you're going to prevail. It's kind of the same way. If you're a true holder in due course, you're going to prevail over these claims that say you don't have rights to the instrument because you took it for value in good faith without notice. It's just a protective layer. As a matter of course, you should seek to become holders of due courses in terms of negotiable instruments, and you should seek to become bona fide purchasers in terms of real property. All right.
Can I ask something really quick? When you're
Sure.
talking about that double negatives, they cause me to shut down mentally. So when they say you're not subject to personal defenses, so if someone says that due to infancy, due to duress, due to something else, that doesn't apply when you're trying to process, cash, transact, if you're a HDC, right?
Yes, and I don't want to confuse the class because some of those things you mentioned are actually real defenses and not personal offenses. So you need to learn and study the phase mnemonic that I mentioned, which will help you differentiate between the personal and real defenses. But it's not a double negative. The personal defenses do not apply to holders in due course.
Okay.
All right, perfect. Let's move forward. So we got family law, we have commercial paper, and we have secure transactions. Let's move forward into another simple subject, trusts, right? Do we feel that trust is pretty simple? Let's go over one of the outlines for trust because, you know, I could rattle off for you all with commercial paper and secure transaction, but those subjects, the reason I do that is because I feel like they're very abstract, and I just kind of want to talk to you and level with you and teach you the subjects. Trust is a little bit more about memorization. You know, I don't need to explain to you all what a trust is. Maybe we could go over some of the finer points about trust and see if we could learn some things. Will Wasson, who was one of my favorite students and then turned tutors, had this mnemonic Trissy Dunks that I think we're about to learn. So without further ado, let's talk about trust. What worked for Will? I will say Will had 2 or 3 students last administration, they all passed. Will's very thorough, and he failed twice, and then maybe once or twice, I can't remember, I think twice. And then he worked with us, and he passed with flying colors, and he was eager to be a tutor, and I love that. I love that for him. Now he's taking the UBE. I'm not sure if he's taking students, but I'm trying to tell him to take students. Okay, valid trust don't ruin marriages. This is when it was an essay subject. Now it's a multiple choice subject. You don't need to memorize these crazy mnemonics. Like, I do want you to memorize MJBPs for family law, modification, jurisdiction, venue, parenting plan, equitable distribution, alimony, child support, esquire fees, distribution, or dissolution and divorce, because that's a check through about how to write and get essay points. This is more about, do I understand the subject Do I have strong reading comprehension skills? Can I use process of elimination to arrive at proper answers? So valid trust on ruined marriages, well, validity. So a valid trust. Joel taught me this mnemonic. Let's see if I still remember it. I forget. What was the mnemonic for valid trust? I can't even remember. So it has to have valid trust property. So it must be real property, money, or current invested interest. A future interest is not valid property for trust. It has to have a trustee. Must be over the age of 18 and a resident of Florida. Ascertainable beneficiaries. So definitely need to have ascertainable beneficiaries. And certain trusts need to be in writing, if it involves real property or it's testamentary. I really wish I could remember that mnemonic. Does anyone remember that? What is necessary for a valid trust? I need to have a valid purpose. It needs to be trustees. SITTAP. There we go. SITTAP. It was for a settler, right? With intent. Trust race, I think was what T was. Ascertainable beneficiaries, valid purpose. All right, maybe I can't remember that, but it needs to have all those things, right? A settler who's of sound mind. There has to be a trustee. So, one of my buddies just hit me up, and he must be doing well in life because he wants to establish a trust. Why does he want to establish a trust? So that his kids will have protection financially for a long time, hopefully forever, right? It's a way to take assets and to put them into a protected account where someone will manage it as you wish them to. And it could even outlive you, right? It could be revocable or irrevocable. In Florida, they're presumed revocable. But the settler is the person who creates it, and the trustee is the person who manages it, and the beneficiaries are the ones who get paid out by it. Key concept, I know I'm teaching you one key concept for everything. For trust, it's going to be spendthrift provision. So we'll keep that in mind. And if any of you guys have your Google machines out, I want you to Google Chet Hanks. Chet Hanks, that's going to be my example. So valid private trust, right, as property. There's actually something in there. There's a trustee, someone who's going to manage it. Ascertainable beneficiaries. It could be a charity, right? It doesn't have to always be ascertainable or meet certain conditions. The conditions being, Cypress doctrine. It could be a charity or something of that nature. And certain trust needs to be in writing, but we also do allow oral trusts. So types of trust. This is really good to know. Trissy Dunks. Testamentary trusts must be in writing, like will formalities, right? Testamentary means they become effective upon death. Resulting trust. So resulting trust is very similar to a constructive trust. Resulting trust means that when a trust fails, one results, where a constructive trust means that court will create one in the nature of justice. They're both court-imposed trusts, resulting and constructive trusts. A revocable trust, remember in Florida, trusts are presumed revocable. Irrevocable, that's a good way to make it protected, is an irrevocable trust, which means it can't be revoked, but it has to be stated. You have to state that. Spendthrift provisions. This is what I think is very important to talk about. Spendthrift provisions are, sorry, just trying to see if anyone's here. Spendthrift, hey Grace, are you here? Grace, are you with me?
Yes, I'm here.
Okay, good. Can you stay? Because there's just no one on camera. I feel like I was talking to myself. All right.
Oh,
No, it's all right. I just need some visual feedback. Okay. So anyway, revocable trust is it can be revoked. Irrevocable trust means it can't be revoked. Spendthrift provision. If all of y'all looked up Chet Hanks, that's Tom Hanks's kid. He's a rapper, and he's not the best. And he got arrested multiple times for illicit activities. He's your good example of someone who probably made a lot of money. Tom Hanks. I mean, come on, he did Forrest Gump. Like he did that whole movie where it's just him in a coconut. Like he's done a lot of good movies. And then his son, who probably would spend every dollar you gave this kid if he had the chance. You create a spendthrift provision. Spendthrift provisions make it impossible for outside creditors to pierce the trust until the property has been dispersed. So if you really want to have a Chet Hanks proof trust, it would be irrevocable, discretionary, spendthrift trust. Irrevocable because those are the hardest to pierce when comparing irrevocable and revocable. Discretionary because discretionary gives the trustee the discretion to dole out the payments, and he's not going to give it to Chet to fund his rap career unless it was promising. I mean, whatever. I'm not hating on any genre of music. And then why would you want it to be spendthrift provisions? For the most important reason, so that the creditors can't pierce. There are certain creditors who can pierce a spendthrift trust: child support, alimony, Uncle Sam, taxes, right? Very similar to who could pierce a homestead exemption, but it's not the family stuff. It's not the child support and the alimony for a homestead. It's the liens, mortgages, encumbrances on the property. But it's always going to be the taxes. Uncle Sam will get his hands in there. Trust me. Inter vivos created during Sarah's lifetime. Discretionary, like I said, at the discretion of the trustee. Oral, right? You can't have a oral trust. You can't have a oral trust for real property. No contests are not valid in Florida. They love to test that. Please write that down. No contest clauses are unenforceable in Florida. They'll just totally be ignored, and the trust or the will just proceed as if it was never written. You can't have a clause in there that says Tommy cannot contest this trust or this will. Get it? Got it? Good. And then charity does not have to have specific beneficiaries. That's the caveat to ascertaining beneficiaries. It could be site-pres doctrine. I create this trust for helping the universe, and they're just going to assign that to a universe helping charity. You can also have an honorary trust for dogs or cats, or like funeral expenses. And a support trust is used to support a beneficiary. All right, then duties. So duty to prudently invest, duty of loyalty, duty to act personally, and the duty to separate and earmark funds. They love testing these, right? These are the duties of the trustee. One very important thing, they do not have a duty to make the trust profitable, right? Because if you were managing a trust from the year 2021 to 2020, let's say 2022, let's just say 2022, that was not a very profitable year in the stock market. And the prudent investor would have put money in the stock market because that's what you're supposed to do, allegedly. And you would have lost money that year. I don't know if I'm making that up, but I'm pretty close to it. But around that time, you would have lost money. Any investor would have lost money. So a diminution or depreciation in value of a trust assets alone by itself does not signify a violation of trustee duties, right? Making the trust profitable is not a duty of the trustee. Being prudent and separating and earmarking funds and acting loyally and, not using the trust money to pay his own mortgage, like that kind of stuff is frowned upon and actually not going to be allowable. We can remove a trustee, right? The beneficiaries can agree to remove them. The court can remove them or to modify it. These are all things that could potentially happen. Oh, here we go, removal. The removal of a trustee can happen for any serious violation of a duty they owe to the trust. A court can also remove a trustee when their services are so seriously unsatisfactory that they would be doing a disservice to the trust by keeping them in place. Modification, so it's disfavored, but it will be enforceable for waste, illegality, change circumstance, or satisfaction of the trust. Or the site-pres doctrine, which you should all learn. So what I say was the most important thing about trusts? Spendthrift provisions, right? That we're not going to be able to pierce these spendthrift provisions if we're not side creditor unless child support, alimony, or Uncle Sam. Hey, what's number? Sam got mad at me because I put a number on the internet. I invaded your privacy. Okay, what else do you guys want to talk about? And girls and ladies and wills. Wills are good to talk about. Let's do wills. Wills are actually tough. I think wills is much tougher than trusts. Why do I think that wills is tougher than trusts? Because historically it's been tested more dynamically, and because there are more nuances to wills than trust. Now, to be completely fair, you'll make more money creating trusts for people than creating wills for people. It's just on the Florida bar, this seems to be a tougher subject. So mental health check-in. Grace, how's your health mentally?
Good. Yoga.
Yoga, nice.
Yoga helps, yeah.
This is my mental health. That's Boca Chica. That's where the Atlantic Ocean meets the Gulf of Mexico. Me and my boy Jason went out there on jet skis. It's chill. All right, I was prepped. Gang. Oh yeah, it's Cyber Monday until 12. All right, let's talk about wills. So intestacy means you die without a will, right? Probate means everyone's fighting in court because you died without clearly telling them who was supposed to get what. Intestacy, so how does it go? So spouse with no lineal descendants, the entire estate goes to the spouse. The spouse and lineal descendants of the spouse, the entire estate goes to the spouse. Spouse and decedents not lineal to the spouse, half remaining estate to the spouse. Okay, that's if Tommy and Brittany are married, but Tommy has kids from a previous marriage. Brittany dies. Tommy dies. Brittany will get half, and the kids from the previous marriage will split the other half. Lineal descendants, but no spouse, equal shares to lineal descendants, right? Tommy's married to Brittany. Brittany died. Kids from the previous marriage will get it. Parents but no lineal spouse, parents will take. Siblings but no parents, lineal descendant spouse, siblings will take. No parents, lineal descendant spouse, and may sheet to the state. Just know they're going to try and give it to someone. Has anyone ever seen or read Lemony Snicket's Series of Unfortunate Events?
No, I've seen the movie Decedents. Have you seen that? It's a comedy.
No.
Yeah, at least look that up one day when you're really bored. It's funny, but you'll like it. It has a lot of legal terminology in there.
All right, I'll check it out. All right, so no one saw that movie though, really? Or no one knows that book that I'm talking about?
No.
Lemony Snicket's A Series of Unfortunate Events. Point being is the court will find someone to give the money to before it just goes to the state, the uncle, the aunt, or someone. But
That's the one Jim Carrey was the uncle.
Yes, exactly.
In the movie.
In the movie, Jim Carrey. Yeah, and the point is, the dude is trying to kill the girl and the boy because he wants to get the fortune, the Beauregard fortune. Anyway, that's what will happen if there wasn't a great uncle. It will go to the state. Just remember, key tenements of this is Florida is per stirpes distribution. Per stirpes means that when someone dies without a will, we're going to go down the line. By the next slide, yeah, we're going to go down the line and distribute on the first level. So A and B are married; they have C, D, and E. A and B die. Let's say A is dead, then B dies. C, D, and E each get 33%. Now, let's say there's grandkids. Let's say there's C, D, and E, and then E has F and G, and then E dies. This is how it's going to be distributed. B 33%, C 33%, and then F and G, the kids of the grandkids, right, of the dead kid will split that 33%. So they'll each get, let's say, 16.5%, right? That 33% is locked in on the first level of distribution. That's what per stirpes means. If you don't know what per stirpes means, Google it, look at some trees. It's very important. Will formalities, wills have to be tested by 2 competent witnesses. Definitely know that. It needs to be signed in the presence of 2 competent witnesses. And also know, if you have a will and then you sign it, and then you put dispositive material after the signature, it invalidates the entire will. So if I write a will, I sign it, and then after a will I say, and I want to give Tommy my canoe, that's going to invalidate the whole will. You can't put dispositive information after the signature. In Florida, you also can't partially revoke a will. You can't just like cross.
Don't they
something
have
out
it
and be
where
like,
the witnesses have to see? Don't they have it where the witnesses have to see each other sign also?
yeah, in the presence of two
Right.
competent witnesses. Yeah,
No, but it says
I think I lost her.
in the presence of, so that
Yeah, they have to see each other. Okay. Also, if there is a will that disappears and you say, hey, these are the contents of it, it can be validated by two disinterested witnesses. So remember, the concept of two comes up a lot: will formalities, testamentary trusts, deeds. We like to have two witnesses in Florida. Okay. Challenges to testamentary capacity, insane delusion, undue influence, fraud, duress, mistake, or tortious interference with an expectancy. These are just reasons why you don't have testamentary capacity. Let's learn something today. Trust is a settler, wills is a testator. Vocabulary. Okay, a codicil. Codicil is an amendment to the will. You can have a codicil if it complies with will formalities. Destroying the codicil will not destroy the will. Destroying the will destroy the codicil. But remember, if there's destruction or revocation, that's called, there needs to be the physical act plus intent. If you mean to destroy the will but destroy the codicil, you've actually done nothing, right? You have to have physical act plus intent. So a codicil is to revoke something. Codicil is a testamentary supplementary document, similar but not necessarily identical to a will. It's amending or altering the will. Pretermitted parties can be a pretermitted spouse or a pretermitted child. This is just, we're going to protect someone who was born after the will was created. You know, you created a will, you had two kids, and then oopsies, you know, COVID baby, you didn't include COVID baby in the will. That's going to be a pretermitted child, and they'll take as if they were going to be included. Unless there's evidence to show that we really hated this COVID baby and we wanted him to have nothing. It could be the same for a pretermitted spouse too, you know? Like if you, in Florida, just know the spouses get protected. If you don't want your spouse to take you, divorce them. And divorce them good. Don't just separate them. Okay, ademption. It's good to know, don't talk about abatement yet. Ademption and abatement, two vocab words. Ademption means that the thing has been deemed, it no longer exists. The concept of ademption means I give Tommy my boat, but then before I die, my boat, you know, fell into the ocean. Well, the boat has been deemed. Abatement is a diminution in value. Like, you know, I leave my $1 million fortune to my 3 kids. Well, I developed a gambling addiction in my last few years, and now my $1 million fortune is like $100. Well, you're still gonna get $33 each. You're just not gonna get $333,000 each. It has abated in value. Slayer statute in general, just like good faith in contracts, anti-slayering in trusts and wills. You can't just kill someone and recover. Like if I try to kill someone, no, if I successfully kill someone to recover from their will, I will be excluded from recovery for a good cause, good reason. So revocation, written instrument, physical act, operational law, no partial revocation. Like I said, you can revoke a will by writing a new inconsistent will, right? So, but check this out. You write a new will that revokes the old will. Then you revoke the new will. That subsequent revocation will not activate the previously revoked will. Once a will is dead, it's dead. There is a very specific doctrine, the dependent relative revocation doctrine. Let's not even go down that rabbit hole, but just know, for the most part, you will not revoke an old will by destroying you will not activate an old will if you destroy the will that the replacement will. You'll just now have no will. You will die intestate. Holographic wills, generally, let's just read this. Holographic wills are not recognized under Florida law, even if the holographic will was executed validly by a non-resident of Florida. For example, a testator validly creates a holographic will under another state's law, then moves to Florida. Florida will not recognize that a holographic will as valid will. However, Florida does recognize handwritten wills if they do meet the execution requirements under Florida law. Yeah, so just no, Florida does not recognize holographic wills. We will recognize wills that are validly executed in other states. We will recognize military wills too. That comes up, like if a will is validly executed under military conditions, like overseas, we'll recognize it here. Holographic will means like in Florida, you can't just write your own will and then sign it. An anti-lapse statute, Florida's anti-lapse statute states that if there's a lapse in a gift given in a will, the gift will pass to the intended beneficiary's surviving family members, provided that those surviving family members are decedents of the testator's grandparents. So, anti-lapse questions can be hard. Like, if a gift is supposed to go to Tommy, right? And then Tommy dies and it was supposed to go to Tommy, then what's going to happen? Is it going to revert back to the testator, or is someone going to be able to take? Well, if they are a decedent of the testator's grandparents, so that would be like, you know, your uncle or even your nephew, someone like that could potentially take instead of it, you know, becoming invalid or escheating to the state. We're going to tend to allow gifts to pass in Florida under the anti-lapse statute. All right, that was not the best ending, but wills in general, what's the key takeaway from wills? I would say per Serpy's distribution, right? You should understand how an intestate estate will be divided in Florida if someone, you know, were in that situation. And the answer is per Serpy's, which means it'll be divided on the first, that's called Serpial level. I don't even know if that's a word. But on the first level, it'll be divided accordingly. And that's the main takeaway with wills. Wills can be tough. We have 50 wills questions at least on that you were assigned for homework. You know, I know I signed a ton of homework, but if you did one, Q bank of high import, I would say wills. And I think that's a good transition into the other one of high import that I would say I would do, which is business entities. So I know it's been a long night, just bear with me, only 3 more subjects to go, and I'll go through them.
Can I say something? You had questions on your Q bank, but when you have to have an administrator or when it actually has to go through a probate, it's dependent upon the amount of the estate itself. They sometimes ask that, and you had it on your Q bank, but you just didn't now say it. So
nice. All right, I'm going to share my screen again, and let's talk about business entities. I recognize that business entities is one of the hardest subjects for people. I think it's because lawyers just hate business until they realize some point in their career that you're part of a business, and that's actually the most important thing. But they go through their entire career like, business sounds like math. I don't like math. I'm not going to do this. But it's not math. It's structure, right? I've been studying my friends or my colleagues and trying to figure out who is happy and successful, right, in the practice of law. And it's not as easy as you would think. You know, people think that they become lawyers, it's just gonna roll off the, you know, you pass the test and everything just falls into place. It's really not that way. If you go big law, they're really gonna work you hard, and that's just a matter of fact. And if you go, you know, prosecution or defense, maybe you're going to be underpaid. You know, if you do something that gives you true value, it's really hard to find that balance of like happiness and success. From what I've studied, those who have struck that balance, I mean, they've done a lot of things, but one avenue that I've seen is sole practitioners, people who create their own practice, or maybe not sole practitioners, but small businessmen, right? So with that being said, maybe that's the future. If you want to be happy, you want to be successful, to start your own law firm. Maybe I'm just talking in the mirror right now, but you need to be a businessman or woman. You need to know how to run a business. You don't just need to know how to practice law. You need to know, how should I structure this? How should I arrange my taxes? How should I qualify my employees? Is there benefits to doing this or that? And then maybe you get a lot of money and then you start investing in companies. That's when it becomes real fun. Hey, now I own Apple. Now I own Google. Now, you own these companies. And then somewhere along the line, you're like, hey, you're successful and you're rich. I want you to be on the board of directors of this company. Count me in, how many shares do I get? Right? So like, this is good stuff. You should actually know this stuff the best. Did I do the wills one again? Let me see. No, okay, just leave it wrong. Okay. Just give me 1 second. Sorry. And technical difficulty. No, I'm not. So I just wanted to cough off camera. Okay, so let's talk about Florida C corporations. Well, let's talk about corporations with partnerships. Corporations are big, and partnerships are. Hey, can you ever make sure they're muted real quick? Sorry, if you're out there, can you please make sure you're muted? Okay. All right. Okay, back to the presentation. Sorry. So, okay, corporations versus partnerships. So corporations are big companies. Partnerships are smaller, but there's way more important differences. The difference is that corporations can issue shares. They can issue stocks. They, have articles of incorporation. They're subject to SEC and registration and all these really tough parameters. Whereas partnerships are just like, yo, Tommy, you want to sell peanuts on the street? Right? There's two types of entities that kind of combine elements of corporations and partnerships, and that's what most small businesses are. Those are called LLCs, I just prep LLC, or S corporations. I keep saying this every year. We're going to become an S corporation next year, but they're pretty much the same thing, where they give you the benefit of being a corporation, which is limited liability, and then they give you the benefit of being a partnership, which is flow through taxation. Because at its core, a corporation has unlimited liability and double taxation. I'm sorry, a corporation has limited liability, pardon me. A corporation has limited liability and double taxation, whereas a partnership has unlimited liability and flow through taxation. General partners are subject to the most liability, right? Corporations, C corps, are subject to the most tax. That's why we like to find a happy medium. In law, maybe there'll be a PC or a PLLC or some sort of corporate, professional corporation that will combine elements of, like I said, limited liability and flow through taxation. Ultimately, that's what people want. That's what business owners want. They want to pay less tax and they want to have less liability. When we say liability, what do we mean? We really mean if the thing goes bankrupt. How much money are they going to get? Are they going to get what I invested? Or are they going to come after me, my house, my dog's collars, and everything I own? Right? President Donald Trump, his companies went bankrupt 3 times, right? He's never been broke himself. Why? Because he created entities that have limited liability. So they went broke. He didn't go broke. That's kind of business strategy. I'm not saying anything for or against him at all. I'm just saying that's why you can see someone saying, oh, someone went bankrupt, but they're still rich, because their entity went bankrupt. They have limited liability. Okay, corporations. How do we create a corporation? articles of incorporation. Make sure you know that. You need to create a corporation with the articles of incorporation, which are going to set out, you know, most the corporate charter and how many shares are going to be authorized and things of that nature, right? Whereas a partnership just has a partnership agreement, but doesn't even need it. A partnership is started if 2 or more people carry on with the intent to, you know, do business together. That's a partnership. Corporation is very formal. Corporation is regulated by the SEC, by, you know, Act of 1932 and 1933. Corporations are under heavy regulation. So we have incorporations, articles of incorporation have to state all these different factors. They have the bylaws. You definitely want to know what incorporators are and what they're liable for. We'll get into the nitty gritty of these things in my complete course, but just know that business entities is tough. De jure, de facto incorporation by estoppel. De jure, think of like soup de jure, it's perfect. De facto, they tried to file articles of incorporation but didn't do it perfectly. We're still going to recognize it. And then corporation by estoppel means we're going to stop you from denying your corporate status. S corps, like I said, are like LLCs. They are corporations that elect flow through taxation. LLCs are like partnerships that elect limited liability status, right? So, like I said, they're hybrids. LLCs are hybrids between corporations or partnerships. I think the best way of thinking about it is like, technically, IBIS Prep, I'm a sole proprietor that elects to be taxed as an LLC. That's a fair way of thinking about it, technically. Okay, piercing the corporate veil comes up a lot. Piercing the corporate veil means we want to go after the board of directors. We want to go after the company A, not the subsidiary company B. We want to go right after the deep pockets. We can pierce the corporate veil. Alter ego doctrine, thin capitalization, deep rock doctrine, or through subsidiary corporations. Just know what piercing the corporate veil means. It means holding the board of directors or the parent company directly liable. And the reason why is because it was just a shell operation. It was a fraudulent purpose. Or was there some reason why we felt it was appropriate to go directly after the main, let's call it the root of the tree and not just the branches. Equity securities, trust me, I teach for the Series 7. If you know anyone taking that really difficult test, please refer them to us and they can get advantage of the Cyber Monday discount. But I could teach all day about securities, right? What are securities? Securities are tradable financial instruments. They could either be equities or debt instruments. Equity is ownership stake in the company. Debt instrument is you lend the company money with the hope of getting paid back plus interest. Equity instruments are like stocks. Stocks are ownership in the company. You could have common stock or preferred stock. Common stock is bought for the purpose of growth, and you have voting rights and rights on electing the board of directors and rights on if there's going to be a stock split, you get to vote. You have more rights, but you have junior liquidation priority, and you don't receive dividends unless preferred stock receives dividends. So preferred stock is kind of like an equity instrument, ownership stake in the company, but it has debt features in the sense that you own it because it pays dividends. Dividends are paid straight. You get them when they're announced, or cumulative. You get them when they're paid plus dividends that were announced that were missed in arrears. These are all concepts I go into deep dives into in my complete course, but just know the difference between common stock is you're just the people who own the stock in the company and you have voting rights, versus preferred stock is you have dividend rights. You still have ownership stake in the company, but you're not going to have as much appreciation. You're going to get paid dividend priority, and you have liquidation priority. If the company goes bankrupt, common stockholders will get paid out after preferred stockholders. Oh, here's the common stockholders' rights: voting power, right to transfer ownership, dividends, inspect corporate books and records, and right to sue. A derivative suit, right? A derivative suit. You could have a third-party suit where the where the stockholder sues on behalf of the company, or you could have a derivative suit where you actually sue the company. Debt securities I talked about, bonds, notes. Remember, a promissory note, that's a debt instrument. You're lending someone money with the getting paid back plus interest. Commercial paper, these are debt securities that are under 270 days. They're going to be money market securities. Whereas most debt securities are like bonds, notes, debentures. A debenture is unsecured collateral. It's like a trash instrument. It sucks. You don't want to invest in debenture. A bond is more heavily secured. When I say a trash instrument, I'm talking mostly about order of liquidation priority. Think about it like that. Secured bonds will get paid back before unsecured bonds. All of them will get paid back before common stockholders, right? Equity owners. The first to get paid back are going to be taxes and wages, right? Employee wage and taxes get paid first. Then general debtors, then general creditors, then unsecured debtors, right? Secured debtors and unsecured debtors, then preferred stock, then common stock. That's like the hierarchy of payment upon liquidation. Registered bond, it's kept on record, and a bearer bond, it's owned by the bearer, not the record holder. There's so much I could go into with stocks and bonds. I can't tonight though. Oh, here's a liquidation priority. Unpaid wages, taxes, secured creditors, unsecured creditors, junior unsecured creditors, preferred stockholders, common stockholders. Perfect. Right? Secured debt will get paid back before unsecured debt. Like a debenture is an unsecured debt instrument. A bond is a secured debt instrument. The government pays T-bills, treasury notes, treasury bonds. If it says treasury, that means federal. If it's state, a state bond, that's state. If it's a municipal bond, that's a municipality. Municipal bonds are actually one of the most tax efficient instruments in the world. You are free of tax. Those are tax-free instruments. If you want to invest in something purely not to pay tax on it, buy all municipal bonds. If you want to invest in something to try and make tons of money but be risky, invest in common stock. Promoters. So the bar examiners often test on promoter liability. Remember that generally a promoter will be personally liable on a pre-incorporation contract unless the contract clearly negates personal liability and will be treated as continuing offer of the corporation. Even after the corporation is formed and adopts a pre-incorporation contract, the promoter remains personally liable unless there's an novation, a specific agreement by the parties that the promoter will be released and the corporation substituted for the promoter. Not going to go super deep into promoters, but just know they do test about promoters and incorporators. It does get deep, so be prepared to swim. Derivative suits, again, I could go deep into this, but this is just a suit brought by a shareholder to enforce their rights. Mergers and consolidations. So a merger, think about two companies create a new company. A consolidation is like, a consolidation is when two companies combine to form a new company, right? Like A and B combine to form C. We're going to consolidate it into C. A merger, think about it like Pac-Man eating the ghost, right? Merger is when one company absorbs another company. So consolidation is you're creating a new company. A merger is you're having an absorption. These events will trigger common stockholder vote, right? You need to vote for events like mergers, consolidations, stock splits. These are things that would trigger a vote. There are different forms of mergers: statutory, short firm, triangular, de facto, share exchange. Not going to get into tonight. Dissolution. These are just ways you're going to dissolve corporations. There's differences between the ways corporations and partnerships end. These are also things I'm going to go into further detail with. Rules and regulations, they can really test anything. 1932 and 1933, those acts are about truth in securities and regulation of broker-dealers. Blue Sky laws are about state intrastate regulations. Sarbanes-Oxley are in response to Enron, and those are about accounting and having procedures in place to make sure that there's not a lot of poor accounting, for lack of better words. Insider trading, be mindful of insider trading, tippers versus tippies. Everyone could be liable unless you're totally innocent. I'm telling you, business entities this should be kind of alarming some people that this is a very tough topic, because I only did corporations there. So here's some definitions. Ultra vires acts are beyond the powers of a corporation. Watered shares are shares that part of a scheme to defraud investors. They're watered down. Florida business judgment rule is kind of like the trustee, rule. Just because they lost money doesn't mean that we're going to say they did something wrong. And the corporate opportunity doctrine means a director can't usurp business opportunity. If I'm the director of IBIS Prep, I can't take on a student for my own personal gain without giving that opportunity first to IBIS Prep. Okay, so I know that corporations was a lot, so I'll make partnerships more spoken word, if you will. Partnerships is a little bit easier. Partnerships is general partnerships versus limited partnerships. General partnerships, you have to have general partners, people who are liable fully, not just for their investment, but they can be held personally liable. Where limited partnerships have a general partner and a limited partner, or maybe more, but they have at least one general partner, and then maybe multiple limited partners. The limited partners are only liable for their investment. One thing they love to test on partnership multiple choice is if Tommy can be liable for his partnership with Johnny, even though Tommy had no impact on the deal. The answer is usually yes. Via some apparent authority, implied authority, partnership by estoppel, by some theory, we're going to say, hey, it was reasonable for Brittany to think that Johnny and Tommy were partners, that Johnny had authority to enter into this contract. So that's, when in doubt, go with that answer, that you're bound by the acts of Tommy because Susan was reasonable in believing that Tommy was still a partner of Tommy and Johnny Toilets. General partners versus limited partners, you definitely want to understand. An LLP means that they're all limited partners. There's no general partner. But no, in an LLP, you will still be found liable for your own malpractice. LLPs usually do happen. We can see them with, doctor's offices or something of that nature. Without going into too much detail, partnerships, key tenet is flow through taxation and unlimited liability for general partners. Key concept of corporations is double taxation and limited liability. What do I mean by double taxation? Let's say you own stock in Apple. Well, Apple pays taxes as a company, and then you have stock in Apple, you sell your stock for a profit. Well, you're going to pay capital gains taxes on that. Does that make sense? You're paying taxes 2 times on your investment. Whereas partnership, those gains flow through to you as an individual, and you only have to pay taxes on them 1 time. Try and think of any other key points about partnerships and corporations. I mean, they're really tough subjects. We have a lot of good questions on the QBank. I highly recommend going through them and learning about them. Just know that corporations are tough to establish. You have to comply with the SEC and have articles of incorporation. Partnerships are very easy to establish. Partnership is just 2 people doing business, and if there's no written agreement, we're going to assume that they're sharing profits and losses equally. All right. So that kind of moves us into the 2 subjects I actually wanted to talk about today, right? Which are Florida evidence and ethics. Yeah, the QBanks are available. Were you not able to access it today?
No, what I was asking is, after we get done on Thursday and this session officially closed down, we lose access to those QBanks, right?
No, I think we'll honor everyone who's here in the class will have continued access to those QBanks, but don't share that code with anyone else. But we're not going to strip that from you. You don't have automatic access to the complete course if you just did the essentials course, but as a matter of good faith, we're not going to strip those questions from you. So we want everyone to pass, and you can hold on to them. But let's move on to the last two subjects. I'm going to start with the one that's more boring, and then end with the one that's super fun, and we'll call it a night. I really appreciate everyone for bearing with me. I know this has been one of the longest and most difficult sessions, but I wanted to make sure that you at least got a little bit of an introduction into everything. And, you know, if anything, you go back and watch this video and learn some of the basic or essential concepts of commercial paper, secure transactions, business entities, family law, trusts, wills, and without further ado, Florida evidence. I will say this. When I took the Florida bar exam, I did really well on evidence federally. I did average on Florida evidence. Why is that the case? Because it's really hard to keep the two straight back-to-back days. You know, I'm a human being, and I just kind of, some things, you know, in my own life, I was like, you got to chalk some things, take some losses. I mean, now looking back on it, of course, I wouldn't do it the same, but I did not do as well on as I should have on Florida evidence because I admittedly got tripped up on distinctions between Florida and federal. So take that advice that that's something to overcome. That's something that we are projecting will be difficult. So you want to really make sure you have a good distinction if you're taking the MBE in Florida of what the distinctions are, and be prepared to utilize the Florida law on Tuesday, dump that out, and utilize the federal law on Wednesday. It's much easier said than done. I'll admit that. So just some key things about Florida evidence that I think are important. You know, I don't know if I love this PowerPoint. I think I have a different one I'm going to use. Sorry. Okay. It's the same one. Sorry, give me 1 second. Florida. Let's look at this. We haven't really looked at these attack sheets yet today. I just moved that item, not on purpose. Okay, perfect. So Florida evidence is tough. A lot of different things that we could focus on, but I just want to see like what's really interesting. So just like federal, there's some policy-based exclusions, right? Subsequent remedial measures, offers to settle, offers to pay medical expenses, plea bargains, liability insurance. These are things that, you know, are not admissible to show guilt, but may be admissible to show ownership or control. They do like to test them a good amount. So Florida's moved back to Daubert, which is also the same as federal in terms of expert witnesses. This is a good thing they test in Florida, that we don't recognize the learned treatise exception in Florida. So it cannot be read into record as substantive evidence or used to bolster experts' credibility, but it can be used during cross-examination of a witness once established as authoritative. That's just one exception that one of my students was key to harp on, that Florida does not recognize the learned treatise exception. You know, similar leading questions are inadmissible on direct, but allowed on cross. Know the difference between refreshing recollection and past recollection recorded. Past recollection recorded is a exception to hearsay, where if a statement was made and it was accurate at the time it was made, and now you have no memory of it, but it was recorded. We're going to allow that in. A refreshing witness is just the witness is on the stand and he can't remember what he's supposed to say. You could show him anything, even a bowl of spaghetti, they say, to refresh his memory. We're not going to read that into evidence. Okay, convictions, impeachment. I mean, similar things as federal law, like when we can impeach and when we can bring things in for substantive proof. It's the same concept that it's got to survive a balancing test. It's got to be relevant and it can't be overly prejudicial. One of my instructors taught me the paradigm shift of evidence, which is instead of thinking about what is excluded from being allowed into evidence, think about what conforms with the narrow constraints and should be admitted. Is it relevant? Is it not prejudicial? Is it not hearsay? Is it not bias? Is it not, any of these things? If it's not any of these things, then we'll let it in. But we're not just going to let anything in. So, these are some examples of things that are admissible to attack credibility. So, felony convictions or misdemeanors that involve dishonesty or false statements. Prior inconsistent statement. In Florida, witness impeached or rehabilitated with reputation, but not opinion testimony, right? We allow reputation, but not opinion. I have heard that Johnny has a good reputation, not I think that Johnny is a good person. That's the difference between opinion and reputation. Character evidence, right? Character can only be proved by reputation, not opinion. So remember, I say let's learn one thing from every single subject. Let's try to run that list again. Family law is going to be the best interest of the child. Secure transactions, I want you to learn what a PMSI is. Commercial paper, I want you to know what a holder and due course is. For business entities, I don't think I told you what I wanted you to know. I just really want you to know the difference between a corporation and a partnership and how they're taxed and how there is liability assigned. In wills, I wanted you to know per surrogate distribution, and in trust, I wanted you to know about spendthrift provisions. Now we've arrived at the one thing that is very important in Florida. In Florida, character can be proved by reputation, but not opinion, right? Generally, character evidence is generally inadmissible to prove action and conformity with it on a particular occasion, but if admissible in Florida, character can only be proved by reputation testimony, not opinion. That's civil cases too. In criminal cases, you can only bring in this evidence, character evidence, if they first open the door. It's the same as federal. They have to open the door for character. For civil, it's only admissible if it's at issue, like defamation or child custody, negligent entrustment, misrepresentation, or fraud. But you can only prove character by reputation, not by opinion, if it is going to be admissible in any form. Same mimic rule, right? We're not going to allow prior acts to show conformity, but we'll allow it to show, specific acts. We won't allow it in for conformity, but we'll allow it to show anything else. Motive, intent, mistake or lack thereof, identity, common scheme or plan. Tommy went around killing everyone with the red-nosed gun. Well, now we can bring in evidence of the red-nosed gun to show identity of the red-nosed gun. Privileges. So one thing, these are good to know. Attorney-client, fiduciary, psychotherapist, patient, physician. So Florida does not recognize the physician, but it does provide that patient records are confidential. Husband-wife is interesting too. Florida does recognize the marital communications, but does not recognize this testimonial, right? So little subtle differences between Florida and federal law that you definitely want to know. Ways to authenticate, right? You can become familiar with someone's voice, but you cannot become familiar with someone's handwriting for the purposes of trial. hearsay, so we don't have exemptions in Florida. Like in federal law, we have exceptions and exemptions. In federal, we have exemptions and exceptions. In Florida, we only have exceptions and non-hearsay, but they are very similar. It's just like how they're classified. Not main thing, but one thing I'll give everyone to take away is if it is a admission, unavailability is not important. If it is a statement against interest, unavailability is required. That's a key difference between the admission, party opponent admission, and a statement against interest. A statement against interest, the unavailability is required, right? You know, excited utterance, you're looking for exclamation point, dying declaration, they must have actually died or, you know, be unavailable now. See, dying declaration is available in all cases, civil and criminal. In federal, it's not the case. It's only civil and homicide cases. Murder cases. So admission of evidence, generally speaking, just know that admissibility is a question for the judge, not the jury, right? Whether it's hearsay, whether it is admissible or not. These are questions for the judge, not the jury. The jury determines, you know, issues of fact. Mandatory, you know, judicial notice, it's a little bit different. It's always must may. In federal, it's going to be must if it's civil and must may if it's criminal. In Florida, it's always going to be must may. They must take notice of it and may accept it as conclusive. Little subtle differences. Again, we can go into evidence all day. I think that's a subject. If I had the privilege of taking Florida again, I would spend more time studying the differences between Florida and federal evidence, because there are a lot of distinctions and they can be really hard to keep straight on test day. Finally, we get to look at ethics. We should have an ethics PowerPoint. I might have actually moved it, but ethics is pretty easy, but it's also actually the most important subject on the bar exam because it's the one thing that's guaranteed 100% to be tested as an essay subject. I tell students, write ethics first, and I really believe that's a strong decision. Now, the only thing that I wouldn't recommend is spending too much time on ethics. I've had students do that in the past where they're like, you know, I have spent so much time writing my ethics that I ran out of time for everything else. That's not the best decision because it's only going to be a small portion of your essay. It's not going to be, you know, the most important part of your essay, but you do want to make sure that you write about it. So why is that important? Because you get your essay, la 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 la, and then part 4 is now discuss the ethical issues. What do most people do? They write it in order. By the time they get to part 4, they ran out of time and they're not writing a good essay, a good ethics piece. If you say, you know what, I'm going to crush ethics and spend 10 minutes on ethics and write that at the bottom of your paper first, then when you go back to the rest of your essay, when you run out of time, that part's already done. And so you're going to gain a lot of points where other students missed it. I always remember in 5th grade, I won the math competition at my school because we all took a test and I got the highest score. Not only did I get the highest score, I crushed everyone. Why? Because I got the test, I looked at it and I was like, wait a minute, the questions at the back of the test are easier than the questions at the front of the test. I'm gonna do them first. We all ran out of time, but I answered like 40 questions. Everyone else answered like 15 questions. Why? Because I was smart. I attacked it from the back. It's like if you give me a maze, I'm definitely starting at the end, not at the beginning, to figure out how to get back to the beginning. It just makes sense in my mind. That's how I would think about this. All the points on the essay are going to add up. Ethics is easy to get. You might as well start off by writing a beautiful ethics statement and do it quickly and concisely and properly and knock it out of the park. The first statement is, where do the rules of ethics come from? And I was trying to pull up the PowerPoint. We'll have it in here sooner than later, but we have a statement that says, like, the rules of ethics are derived from the Florida Rules of Professional Responsibility, the creed and oath of the Board of Bar Examiners, the distributions of the Florida Bar, and other, some beautiful statement that really gets you ready to be like, I'm about to tell you about ethics. Tell the reader where all the rules come from. Then you're going to go over the main rules that we're always going to see. And just to kind of go over them quickly, we have duty of confidentiality. A lawyer may not reveal information relating to the representation of the client, even after death, unless client consents to full disclosure. Disclosures implied authorized in order to carry on the representation, to prevent the client of committing a future crime, to prevent death or substantial bodily harm, or detect and resolve conflicts of interest. Scope is no more than necessary. So duty of confidentiality is different than attorney-client privilege, right? Attorney-client privilege is owned by the client, and it is evidentiary rule. The duty of confidentiality survives even death, right? It's much stronger. So the attorney-client privilege is an evidentiary rule that applies only to communications during the professional relationship. Well, the duty of confidentiality covers all information related to representation, however and whenever derived. So think about the duty of confidentiality being an ethical rule that's even stronger than the evidentiary attorney-client privilege. They test conflicts of interest a whole lot. You really want to be strong about conflicts of interest. So what's a conflict of interest? It's going to be obvious. The lawyer represented this person in a previous matter. Now they have to get consent from the parties, and they have to reasonably believe that they could handle this representation, right? A lawyer who represents a client in a matter must not represent another client in the same or substantially related matter in which the former client interests are materially adverse, or use information relating to the representation to the disadvantage of the former client. So the only reason they could do it is if they reasonably believe that the representation won't be adversely affected and the client gives informed consent. So they like to test screening and imputing. Imputing means, Tommy, Johnny, and Sally. Well, Tommy's conflict of interest will be imputed onto Johnny and Sally. Now you can be screened out. We can screen Tommy out, and it won't apply. So imputed disqualifications. The disqualification of a lawyer due to a conflict of interest with present or former clients is imputed to the rest of the lawyer's law firm. The exception is the conflict is personal in nature, and the conflict does not pose a significant risk of materially limiting the representation by the other lawyers in the firm. When a lawyer has terminated association with the firm may represent a client whose interests are adverse to the part of the lawyer's client that the lawyer took with him, unless it's the same or substantially related matter. No lawyer remaining at the firm has confidential information about former client that's material to the matter. So far, conflict of interest, duty of confidentiality. Have your antennas on red alert for those two, because they come up very often, and if you can spot it, issue. The issue is whether Tommy breached duty of confidentiality. The rule is all lawyers, you can write these IRACs and really get a whole lot of points, and people spend 3 minutes on them when I'm asking you to spend 10 to 12. Okay, compensation from a third party. Can mommy pay for your lawyer? Yes, but remember, the lawyer represents you, not mommy. And insurance companies have a little more say, right? You decide when to settle, not mommy, but the insurance company, they can actually have the right to decide whether to settle the case, because they're pretty much, if they didn't pay for it, you wouldn't have a case. Attorney's fees are tested a lot, in two different ways. The one way is referral fees. Referral fees are actually not allowed in Florida. Wink, wink. Meaning you can't get referral fees unless you get consent and you participate in the case. So that happens all the time, right? Contingency fees are fees that are paid if you win. They're not allowed in domestic cases or criminal cases. They have to be reasonable, they have to be agreed upon, consent, and they have to be calculated in advance or show the person how they will be calculated. So that's tested a lot. Contingency fees, referral fees, and then just attorney's fees in general. They just have to be reasonable for your expertise and your time, and you have to be reasonably competent and all these different factors. So, going over these ethical rules, be confident in writing about conflict of interest, be confident in writing about duty of confidentiality, and be confident in writing about attorney's fees, talking about how to charge them when it's appropriate and how to charge contingency fees, and about getting referral fees. Attorney's fees, only when they're provided by statute or contract. Here we said contingency fees, they need to be signed by the client attorney, have a calculation of how they're going to be paid out, and 15 to 40% are the guidelines. You see these a lot in personal injury cases, right? Referral fees, exactly. It's unethical to pay referral fees, but if they worked on the case and they got consent. A lawyer must not commingle funds, so duty not to commingle. Certainly, if they, mix the operating account and the the client account, that's no good. Definitely no good. How about can the lawyer take an interest in the property? Again, if it's fair and reasonable, disclose in writing, they're allowed to seek independent counsel and they give informed consent. It's kind of like all these things. Like, no, we don't allow it unless you get the consent, it's fair and reasonable on all these different factors. And then the last thing they really love to test is attorney solicitations and communications, right? Advertisements. Can't be false, deceptive, or inherently misleading. Like, you can't say, and this is kind of been seeing this, I'm not going to snitch on anyone, but I've been seeing some brand new attorneys because, I know a lot of them, and they get into the field and then like a week later, they're like, I've won 100% of my cases. Well, yeah, if you've only had one case, saying you won 100% of your cases is false or misleading. Remember, on this test, it's being graded by the Florida Board of Bar Examiners. They literally are the ones who oversee the rules of ethics. You want to really advise the attorney to do all the things that a saint attorney would do to avoid conflict with the board, So you don't want to have any false or misleading advertisements. Solicitations, you cannot solicit from anyone you don't have a prior relationship with. We do allow accident victims, if it's in writing and it's at least 30 days since it's passed. And then lastly, when you can't knowingly communicate with the represented person, if you know that they're represented, and if you deal with an unrepresented person, you should state or imply that you're disinterested. Just tread carefully as a lawyer is the key advice here. Don't commingle funds. Don't take on a case if there's some conflict of interest that you should be aware of. We also should talk about duty of decorum, duty of candor. You have to act like a good person, right? Duty of loyalty, you have to be loyal to your client. Duty of confidentiality, not charge a excessive fee. This is one that people miss. Duty of competency. The lawyer can't be dumb and act like an idiot, right? He has to employ the preparation, skill, expertise, knowledge that a reasonably, prudent attorney would provide. And then decorum in the court, and outside the court, and the duty of candor. You have to be truthful and not, submit frivolous claims to the court and things of that nature. I really do encourage everyone to take ethics more seriously than you ever have before. Why do I say that? Because the test is very hard and you can pass or fail by 1 or 2 points. You don't need me to tell you that truth. So multiple choice, do my practice questions, try to get access to more practice questions and study the outlines and do as well as you can. But on test day, it could come down to the wire with multiple choice. I'm not going to sugarcoat it. Essays are the area where it's like, you know what? I can put matters into my own hands. I could prepare myself to write such great essays that even if I, don't do as well in multiple choice because, I pick C instead of D or whatever, my essays are going to be 70s and 80s. And how do you write great essays? By getting extra points. Ethics is one of those places where people leave so many points hanging because they run out of time. you're going to run out of time. Even if you have a time extension, you're going to run out of time. No one's ever taken the bar exam and be like, man, that was way too much time. You know, I wish I had less time to write that because I just had too much time. Like never when you're writing essays. So why? Because you can keep reaching for more and more points. Ethics is one of those areas. I encourage everyone to go over all the essays I've assigned so far and look back at them. They've all had ethical components. I would encourage everyone to write those ethical components and try to get as many points as possible, because that way you'll train yourself on test day to spend the first 10 minutes of writing just churning out ethics points. So I know this was a whirlwind of a lecture, never done this many subjects in one night, but I didn't want to end the course without feeling like I touched on everything. Sam, what's up? You have any last thoughts for the class since you're still here?
You guys went in this evening. I'm so proud of you guys. I know that was a lot of information, but that was a lot of valuable information. You killed that, Drew.
Yeah, I mean, it's whatever. It's nothing to me. I would encourage everyone to go on our Q Bank and do the Florida multiple choice questions. Please, you know, the essays. We've assigned, I think, 4 essays. Contracts towards real property, common law, okay, 5 essays. We assigned 5 essays. If you can write the 5 essays and do all the questions on the Florida multiple choice Q Bank, you will be so well prepared for heading into December. If it's a little bit overwhelming and you're not able to complete everything, don't worry. Just coming to these lectures and being present, you've done a lot more than other students. And just know that, you know, one of my favorite quotes, Babe Ruth, yesterday's home runs don't win today's ball game, right? No matter what you've done for the last month, it doesn't matter. Wake up tomorrow and outwork everyone. And then the last thing is, what was the password for today? The password was IBIS. I named my business IBIS Prep. Why? Because the IBIS is the last bird to leave when a hurricane comes and the first bird or creature to return when the hurricane passes. So when the hurricane comes, all the worms get churned up and it's the only bird in town and it's having a feast. So actually the IBIS prays for hurricanes because it's an opportunity for them to, you know, it's their time to shine. That's what I've always taught my students about this bar exam. So many people have the wrong attitude. What was me? Taking this test is going to be horrible. Absolutely not. This is a cool time where you're being called upon to study and to learn. Never again in your life is this going to be what you're called upon. You're going to have to work. Now you just need to learn and you want to show out. All of my students who scored extremely high have either gone on to work great jobs or have gone on to work with me because it opens doors. So don't have the attitude you're going to, woe is me, get a 136 and maybe pass. Have the attitude, yo, I'm going to study so hard. I'm going to knock this test out of the park. I can't wait for test day. That's my opportunity to be like the IBIS and have a feast, you know, to, as the kids say, eat and leave no crumbs. So I'm really happy that everyone was able to join us in this Florida Essentials course. Sam, this was your idea and it was a great thing. I hope to see everyone in the complete course starting on Monday, or to do one-on-one tutoring with us or whatever it may be. Just know that you're never leaving us. We're not leaving you. And we're going to see you all the way through this thing. If you're coming to the MBE course on Thursday, I will see you there. And pay attention because we're going to have a full assignment for a simulated exam. So just because this is the last class, the course doesn't technically end until Monday. So pay attention and follow up. Thank you all so much.